We'll now move to the panel discussion portion of our symposium, where each panelist will have 15 minutes to speak to a particular topic with questions and comments from other panel members. Let's begin with Mark Danner, who will address how the United States got into torture. And I'll start the process by asking Mark a question. In your New York Review article of February 5th, you state that George W. Bush signed the Memorandum of Notification on September 17th, 2001, and that this document, drafted by the CIA, was the original document authorizing torture. Can you explain the full significance of this revelation?
I shouldn't say this is a revelation because, in fact, we don't have that document. I mean, what Jameel said is very true, that we have an immense amount of material about torture, an immense amount of documents, extraordinary wealth of government reports from the Office of Professional Responsibility in the Justice Department to the Senate Armed Services Committee to the Inspector General at the CIA to this recent report from the Senate Select Committee on Intelligence. We do not have the Memorandum of Notification of September 17th, 2001, which was the document that granted various powers to the CIA from the president, including the power to take lethal action against al-Qaeda and its associated forces, and as well the power to imprison and interrogate terrorists. We have never yet seen that document. We've seen it talked about. John Rizzo, who was the acting counsel of the CIA at the time, has written about it most recently in his memoir. But it seems clear that this is the document that gave the original legal authority. You know, it's interesting that while we have so much information, and we've had it for a long time, you know, we've had John Yu's memo, the main one, since June 2004, which is to say nearly 11 years we've had it before us. So we have known and lived with this forever. It's an interesting reality that the one area that has not been treated extensively in a report is the political responsibility for making the decisions about torture. We don't know who gave specific orders at a specific time that Abu Zubaydah be tortured. We generally know. We know that Condoleezza Rice took the decisions probably to the president about this time. We don't know about any real discussions about it. One of the interesting things, quotations I remembered when I was listening to Bob's very interesting remarks was Phil Zellico, who's the executive director of the 9/11 Commission, said, you know, when we wanted to answer ethical questions, we went to lawyers and we asked them, what can we do, not what should we do? And there is no reference in the record that I know of anyone asking a question about what should we do. We get it later with the JAGs, with Admiral Mora, for example, when you have this discussion in the Defense Department. But the crucial decisions that really happened at the end of 2001 and then in the spring of 2002, we don't know, so far as I can tell, by my reading of the record, who exactly debated this. We have no record of people looking into the history, as Rebecca said, of CIA, other CIA historic involvement in torture. We have no record of intergovernmental consultations. It's a remarkable vacuum in the story. It's remarkable in part because it, in some ways, is the most crucial part of the, it is the decision making. It is our elected representatives at the end of the day taking responsibility on our behalf to torture. And we're not quite sure how it was done. We do know that the decisions, and I would say this anyway, that the decisions about the Geneva Convention were absolutely critical. The notion that these prisoners would not be counted either POWs or indeed under the Geneva Conventions at all under Common Article 3. That decision, at least announced in February 2002, was critical because it left their status basically unprotected. But we know, as I said in my opening remarks, that even in the early fall of 2001, you already had CIA, people in the CIA saying, and these are lawyers, again, lawyers, saying that if we torture, we can get away with it if we're saving thousands of people. So there is this rationale at the beginning that pre-exists the program itself for what would make torture right and legal. But the actual document that you're asking about, unfortunately, we don't have. And it would be critical to see it because it's central not only to torture, but drone warfare and many other things. And that memorandum has never been made public.
I have one short anecdote about that document and how fiercely guarded that document is. So we sued for the release of that document. It was the same litigation that eventually resulted in the disclosure of the OLC memos. But the government's position with respect to that document, the memorandum of notification, they gave us what's called a GLOMAR response initially. They said, we can't confirm or deny that the document exists. And then after President Bush transferred the prisoners, the CIA prisoners to Guantanamo, they dropped the GLOMAR response and said, well, now we can confirm that it exists, but we're withholding it in its entirety for national security reasons. Which is not an unusual position for them to adopt in this kind of litigation. But we had a hearing before a judge in New York, and the judge said to them, the ACLU is arguing that at least some parts of this document should be released, that maybe some of it can be withheld on national security grounds, but not all of it can be withheld. And the government said, well, that's not true, Your Honor. While there may be some parts that are not as sensitive as other parts, even the font of this document is classified. They really said that. They really said that. And they've been able to withhold it since then. That hearing was almost a decade ago.
Mark, could I ask you, have there been people in the government at various levels, high, middle, low, who've pushed back on this program? Does everybody go along with it?
No. There were definitely people who pushed back. The most noted one is Admiral Mora, who's the JAG within the military, the Navy, was the most eloquent and I think the most effective. Although at the end of the day, they decided to do it anyway, using John Yu's language, actually, eventually. But there were certainly people within the government who pushed back. Not enough of them, obviously. Another thing to remember, of course, is that this program was very closely held at the beginning. Yeah. I mean, there weren't a lot of people to push back. It was
So even when you get down the line, you're still got a very limited, controlled number of.
I think so. I mean, when you get down the line, you're talking about interrogators, and this was a very small number of people. It was very closely held within the CIA itself. Certainly at the decision-making level, it was very, very closely held, no question about it. But I also think it's fair to say, and Rebecca pointed this out, we knew about it from an early, even as we're saying it was very closely held, December 26th, 2002, stress and duress techniques. Right. This piece was Barton Gellman and Dana Priest on the front page of the Washington Post. 3 months later, front page of the New York Times. 2004, the huge document dump associated with Abu Ghraib, in which in June was John Yu's August 1st, 2002 memo. Right. Waterboarding was first talked about in the Times, I think, in 2005. So this part, Jameel, I thought, put his finger directly on it when he said, our institutions have failed to deal with this. This has been before our institutions since at least 2004, but probably earlier. And, we haven't talked much about Congress, the detention, the Military Commissions Act, in which essentially officials were held harmless for doing these things. I mean, that's now in the law. Our institutions have indeed taken action, but they've taken the opposite action of what we would expect and what we would want. And that, I think, is extremely important to observe here, that the politics, in 2005, the Military Commission Act was introduced in the fall. Why was it introduced in the fall? Because 2006, I beg your pardon, because an election was coming up. Right. Because the midterm elections were coming up, and a senator from Illinois named Barack Obama got up on the Senate floor and said, well, we all know what this is about. An election is coming up. No one's going to vote against this thing in an election, the Democrats are not going to filibuster it. They're not going to risk being called soft on national security. So it's extremely important, I think, to underline here that the politics have cut in the other direction. I'm talking about the broader politics, not the politics of this room. And it's a very grim reality to try to come to grips with. It doesn't mean that people are horrible and savage or anything else, but it means perhaps that they're afraid and that fear is a very lucrative political emotion. And when you can use fear, you can make people do things that we would not want them necessarily to do and support things that we would not want them necessarily to support. I mean, it's interesting, this is a final point here, that my subtitle was Torture in the Forever War. And one of the interesting things about the release of the executive summary of the Senate Select Committee on Intelligence report in December was Obama was nowhere to be seen.
Right.
He was nowhere to be seen. You know, he didn't come out and say, well, this is, you know, we're not going to prosecute anybody, but however, this stuff's terrible, it didn't work, it's awful, this is a lesson for our country. I mean, that is what he is paid for to some degree, moral leadership. And to come out and make statements like that would have been supporting his own position.
Right.
That's his position, you know, and he didn't. And the question is, well, why didn't he? And I would say the politics cut in a certain direction, number one. But number two, the forever war. You know, he is bound at the hip when it comes to drone warfare, when it comes to the so-called light footprint of the continuing war on terror. He is very, very dependent on the CIA. The CIA is the action agency for the war on terror, in effect, the CIA and JSOC. And I think this puts, you know, not only our president, but the so-called moral leadership in the country in a rather vulnerable position. And the fact that this war has gone on and is about to be reauthorized in a very interesting and very dubious way, apparently, is extremely important to this discussion, I think, critical to it.
Can I say a couple of things about how torture actually helps to create and perpetuate this fear? So we've been living in a way since September 11th in what some people have called security theater. And if you've ever been to an airport between 2001 and now, you know what I'm talking about. You stand in line, you take off your shoes, you take off your belt, you put your little liquids in an exactly quart-sized baggie, no bigger, no smaller, and all of that is to remind you that you should be afraid. And in the same way, the knowledge that our government has tortured is also designed, or if not designed, has the effect of reminding us how frightened we should be. Because it goes like this. If we think of our government and our country as a leader in the world of human rights, as which we may laugh in this room, but many people in this country do think that, and who are not perhaps as aware as some of us might be about all the history of our government. But we think of ourselves as a good government. We think of ourselves as a moral government, an ethical government. And if our government, a good government, is driven to do such terrible things, think how terrible the people must be that we're doing them to. Think how really terrible the danger must be that we are in because they've been driven to do these awful things. So I think that in a sense, torture not only is perpetuated because people are afraid, but the fact that we know it's happening perpetuates the fear. I also want to say that I think one thing that happened when President Obama took power as, in 2009, was that he discovered that there are limits to the power even of the President of the United States, and that there are entrenched infrastructures in the US government that he did not have as a person with, even with the mandate he had in 2009, the power to actually go up against. And so we see him in the very, at the same moment that he's signing his executive order saying that there's going to be no more torture, saying we should look forward, not backwards, which is precisely what he repeated when the Senate Intelligence Committee report came out in December, that we should be looking forward, not backward. These things are in our past. They should never happen again. But until someone is held accountable, until we have the official, as you were saying, the official mark that this was wrong. And what the convention that we signed requires us to do, as Juan Mendez says, is investigate and prosecute. We signed a convention saying we would do that. Until we've done that, in the minds of the people of this country, nothing wrong was done. On an official level, there is no official imprimatur on the discoveries that we've had. They can go on being in the public domain, but it doesn't matter.
We have time for one more comment on this topic.
Mark, well, this is a little pet peeve of mine, but for probably 10 years, the New York, you're a journalist. The New York
You say that
Times-
very accusingly.
No, I say it with great admiration. The New York Times refused to call it, they reported, as you said, but they called it enhanced harsh interrogation techniques, and they would not call it torture. Now they call it torture all over the place. I mean, the Times. Now, what's the sort of internal journalistic ethic on not having used that term torture? What were they?
Well, I can't. I used to work for the Times quite a while ago, but not
I don't
as
mean to
recently
ask
as that.
that you would know in the inside. But
Sure.
What's the?
I think they confront a situation in which some people characterize it as torture, and the government claims that it isn't. And the government has made a ruling, as official as it comes from the Office of Legal Counsel and other bodies of the government as well, that it isn't torture. And the Times feels that it's taking an editorial position in its news columns by calling it torture. So they will try to straddle that problem by saying enhanced interrogation techniques, which some criticize as torture. And I would prefer, obviously, that they use the term torture. I think it's been pretty well established that that's what it is. It still is. They still straddle this. In the editorial columns, they now call it.
But the editorials have come out and called it torture.
Yeah, they have. And the editorial column is a very different space in the paper, completely separate. In the editorial, I think the editorial columns have been the editorial itself, editorial board, has been very good on this issue. But it is true, it's been a long time. They also have called waterboarding consistently, feigned or simulated. Thank you. I couldn't remember. Simulated drowning, which is actually quite wrong. You could call it interrupted drowning. It's not. There's nothing simulated about it. Nothing's being simulated. It is drowning. They just stop before you die. So I really thought that was a very bad decision, editorial decision. There are people. There's a kind of ideological chief at the Times, as at most newspapers, who decides these things, and then it continues. But I agree. I think that was a bad decision, and it's irked me every time I read it, and I've read it a great many times.
We need to close this fascinating discussion and move to another panelist. Jameel Jaffer will now address how far have we come in reestablishing a regime of lawlessness about torture, and what can we expect for the future? And I'll begin with a question for Jameel. As one of the lawyers for the detained author of Guantanamo Diary, can you speak to the various arguments used by the CIA and Pentagon, as well as the executive branch, to avoid accountability for the torture your client so graphically describes?
So I don't know if everybody knows about this book, but there's a book out now called Guantanamo Diary. It's written by Mohammed Slahi, who's been at Guantanamo since the beginning, so 13 years now. And he's one of our clients, and he wrote this manuscript in custody, and it's an account of his detention and his torture at Guantanamo, and it really is an extremely powerful and riveting read. If you haven't read it, I can't recommend it more highly. If you don't believe me, you should read Mark Danner's review of it, which was on the cover of the New York Times Book Review last weekend. So there have been a dozen lawsuits brought against various officials for the torture of prisoners in CIA custody and in military custody as well. And they've all been kicked out of court on procedural grounds. Some of them have been kicked out on state secrets grounds. Some of them have been kicked out on Bivens or special factor grounds. In other words, the courts have held that national security or some version of national security is a special factor that makes a remedy unavailable where it would otherwise have been available. And there are other cases that have been kicked out on qualified immunity grounds on the theory that even if what happened was against the law, it wasn't so clearly against the law that anyone should be held accountable for it. The one common thread to all these cases is that they were all kicked out at the threshold before anyone had an opportunity to make a case in court or to submit facts or, let alone challenge facts submitted by the other side. And so the result is that there hasn't been any judicial ruling as to the lawfulness of these methods, even though more than a decade has passed since the methods were introduced. And then, as other panelists have said, no senior officials have been charged with any crimes for the adoption or authorization of these methods. And so you have a situation where the law has essentially been silent. Or maybe I should put it a little differently. I mean, you have a situation where the Bush administration created a kind of framework for torture, and this administration has created a framework for impunity. You have a body of law now that essentially holds that torture may well be illegal, but if it's illegal, it's not the kind of illegal that the courts will care about. Which is, I think, obviously quite dangerous. I don't know if I can cede a couple minutes of my time to Mark, but I have a question for Mark that's related to the question that Bill you asked me. When people talk about the last 13 years, lawyers especially, one of the descriptions they give, or one of the phenomena that they comment on, is the expansion, the vast expansion in executive power, the power of the executive branch vis-a-vis other branches. But something you said made me wonder whether that actually captures what's happened over the last 13 years. Because although it is true in many respects that the executive branch has arrogated to itself all of this power that the other branches have had in the past, it's also true that the president seems to have very little power vis-a-vis the intelligence agencies. Right. So, you have this executive branch that is extremely powerful, but the person at the top of the executive branch doesn't seem to be able to do even the things that he most clearly committed to do during the campaign.
Yeah, I think that's very true, and it's fascinating. I think the source of that is the political power of terrorism itself. I think that the notion became clear probably to President, I mean, this is completely my speculation, but do you remember the Christmas Day, the so-called underwear bombing attempt? This would be 2009 Christmas. This came a whisker away from working. If the bomb had functioned as it had been designed to function, that plane would have been blown up over Detroit. It would have been an enormous catastrophe. Hundreds of people would have been killed. And I think there was a realization within the White House that this would have destroyed his presidency, that this very much could have made him a one-term president and taken away basically all of his political power. I think it was an enormous shock that reaffirmed a notion that I think already had become installed in the executive branch, which is that they were very much dependent on a set of national security institutions to protect the country from something that almost inevitably would happen, which is you would have a successful attack, a terrorist attack on American soil. And the political power of it could be almost incalculable, in part because you could expect with this attack, unlike 9/11, for the opposition party to absolutely take advantage of it. I mean, all the signs in the spring of 2009 were that national security and terrorism in particular, and torture in particular, was a fertile issue on the Republican side to attack Obama. The key figure in this was Vice President Richard Cheney, who 10 days after stepping down in an unprecedented fashion, went on television, I think the first program was 60 Minutes or maybe it was Fox News, but began attacking the administration for stopping torture. And it was remarkable, and you look at these quotes over a period of months, which culminated in a speech that was given by Cheney at the AEI, American Enterprise Institute, immediately after Obama's speech from the U.S. Archives on these issues. So they had these dueling speeches. Most cable networks carried one and then the other on the issue of torture. And I think there was a newfound sensitivity within the executive branch. Obviously, there are a lot of other issues here. You know, Greg Craig was fired. There were, which was probably a consequence of this in some ways. I mean, it goes beyond a single personality, obviously, but there was an evolution of thinking, I think, in that critical spring and summer of 2009 that, you know what, we are dependent on these national security agencies not only to protect the country, but to protect our political power, and that a successful attack will indeed destroy us. And I think then there's been an evolution of how, more substantively, of how the war on terror has been fought, that Obama essentially has done it by ending the big wars, ending Iraq, ending Afghanistan, and shifting to what has been called the light footprint. And the light footprint is the use of drones, the use of paramilitary CIA forces, and the use of JSOC, Joint Special Operations Command forces as well on small raids. And this means that the entire war on terror increasingly is basically dependent on the CIA. So I think we have given up a lot politically for that dependency, but I think it is there. And the sad thing about it is that people don't really think about it very much, at least in my perception, that the war, one of the goals of fighting the war in this way was to get people to forget about it, because you minimize American casualties. Drones obviously are completely safe for the pilots who are sitting outside of Las Vegas in a trailer somewhere. And so you're fighting a war with very little political cost, but you need the CIA and you need JSOC to fight it. Anyway.
So here's one place where I differ with you a little bit, which is, I think you're absolutely right for the most part, that it is the fear of terror and the political power of terror to, as you say, undo an administration, although it's very interesting that it did not undo a Republican administration, but certainly to undo a Democratic administration. But there was one other reason why torture was being used very early on, and this is coming from Donald Rumsfeld as, the civilian head of the Pentagon, and that was to generate testimony to the effect that Saddam Hussein had been complicit in 9/11. And so in Guantanamo especially, while the CIA was scrambling to put together their techniques, Donald Rumsfeld, there was a group of people down in Guantanamo who were trying to figure out with Diane Beaver, what should we do to these people in Guantanamo who aren't willing to tell us that Saddam Hussein was working with al-Qaeda? And so they sent up a list of things they wanted to do, and Donald Rumsfeld wrote back, and famously he wrote on it, yes, but why is standing limited to only 4 hours? I stand 8 hours a day. And and if you don't know, these stress positions can cause as much pain as anything you can do with an electric current, but they don't leave a mark. And they also have the powerful effect that you're doing that to yourself. But in any case, so I think at least in one case, they were using torture in an attempt to establish something as true that actually wasn't true, and even perhaps to convince themselves of something they knew wasn't true. But I think the general point that the fear of terrorism has completely moved the power, both from the Congress to the executive branch and then within the executive branch out of the office of the presidency in ways that we probably wouldn't have predicted 20 years ago. And I mean, those of us who lived through Vietnam remember wishing Congress would seize back its right in the Constitution to declare war, which we never did in Vietnam. And then we saw again more arrogation under the Reagan presidency, but nothing like what we saw under Cheney and Bush, and even now Obama. So I think you're right in general that this fear of terrorism is profoundly effective.
But this, oh, go ahead.
No, you go ahead.
Well, what you described as, you know, the president's dependency politically on the CIA and the military, I mean, it's probably a general phenomenon that isn't even limited to this subject. But in any event, it may not be limited to this subject in the future. I mean, what you're saying is that we need to, I mean, what I get from that is we have to have some kind of very basic redesign of how we're going to control how the executive branch is going to control itself.
Yeah, we do.
Well, I think that's true. I mean, the
I know
National
exactly.
Security Act. Well, actually, Jameel, you should talk about this. I was just going to say, you know, we're still living, in a sense, under a distribution of power that was developed in 1947, the
Yeah.
National
Yeah.
Security Act. And, you know, we're still living in an emergency state that was put together for the Cold War. And that emergency state has evolved in the way it has very naturally into the war on terror, it seems to me.
You know, I mean, I agree that we need a kind of fundamental reworking of oversight within the executive branch. I mean, it's clearly not, and I think if you talk to people in the White House, if you talk to people 2 years from now who were in the Obama White House, they will probably agree. But you know, I wanted to go back to something that we all touched on, I think, and you know, I said at the beginning that you know, I was talking at the beginning about secrecy and the way that it's distorted our political debate, and I said that we actually had a lot of this information, and I think, you know, everybody agreed with that. We had this information from the beginning, but there's one sort of subset or one class of information that I think for the most part we have been deprived of, and it's a really important set of information. It's the voices of the prisoners themselves. Now, there's some exceptions to this, and the Red Cross report that the New York Review of Books published is one of the exceptions, where you actually hear the voices of the prisoners testifying about their detention. But outside of that exception, you know, you have a pretty categorical suppression of the voices of the prisoners, and in fact of anything that would humanize the prisoners. We sued for the release of photographs showing the abuse of prisoners at facilities other than Abu Ghraib, and for 13 years the government has been able to suppress those photos. It's also suppressed the videotapes of the force feeding at Guantanamo. We sued for the release of photographs of prisoners held at CIA black sites, and there was a photograph of Abu Zubaydah that the government was able to withhold on the theory that the photo showed sources and methods, which is hard to understand. And then when we were able to force loose the combatant status review tribunal transcripts from Guantanamo, these are the transcripts of the tribunals that all of the prisoners participate in at some point, or participated in at some point. We got the transcripts made public, but they were all redacted to the extent that they included testimony from former CIA prisoners telling the story of their torture in custody. And I think the consequence of that is a kind of well, first, a kind of vacuum where you would expect to hear the prisoners' own accounts, but also a kind of dehumanization of the prisoners that allows for the continuation, initially the continuation of the torture policies, and then the creation of this system of impunity that allows the people who authorize torture not to be held to account for it. So I just wanted to, amend my earlier remarks with that.
Could I add that this book, I really highly recommend it. It's a weirdly brilliant book, I think. It's Mohamedou Ould Slahi. It's his account of what happened to him from the moment he was taken prisoner in Mauritania in 2002 to, I guess, 2005, the summer of 2005, when he actually sat down and wrote it. So it talks about Bagram, it talks about being interrogated by the Jordanians, but most of all it talks about the interrogation he was subjected to at Guantanamo. And it's a really I found it a remarkable account. He's writing in his fourth language, which he picked up at Guantanamo. And his language is limited and also extremely effective. And I have been recommending this book a lot to people because I feel like if you're interested in this subject, read it. It's extremely powerful, and I completely agree with what Jameel just said, that we haven't heard the voices, and these voices are still, this book is on the bestseller list. Where is the author? He's not doing an author tour. He's sitting in Guantanamo. It's a remarkable. It's also crazy. Actually, maybe you can talk about that if we have any time. It's insane to me. I mean, this book has 2,500 redactions in it, but here it is. It sits here. You can go out and buy it. It's reviewed in the paper, and the author is sitting in Guantanamo. How did that happen exactly?
Forever.
We have time for one more comment. Yep.
Please.
Well, it's Jameel's,
can you-
Jameel is on, right? So
Well,
let
can
me
you say
ask.
a word
I'm
about
going to
how
take
it
your
was
time
published?
later. So.
Oh, no, go ahead. Well, you were,
Well, so I guess I want to say two things. One is about the Senate report, which a lot of people refer to as the comprehensive account of the CIA's torture program. The Senate investigators, I think they deserve a huge amount of credit for the work they did on that report. It's an incredible document that took just unbelievable amounts of energy and attention over a sustained period of time. But they never talked to prisoners. They never actually interviewed any of the prisoners. And so this comprehensive account lacks the voices of the prisoners themselves. And as to how this came out, it's a long story, but basically it was held. That book was held in a government vault in Washington D.C. for 7 years, and Slahi's lawyers, ACLU lawyers are among his lawyers, but the most important lawyer from the beginning has been a woman named Nancy Hollander. She's represented him since I think since around 2006. But she's the one who's been negotiating the release of that document, and she's gone back and forth countless times with the government, was able to finally pry it out of the government's hands, get them to agree to allow him to publish it in this heavily redacted form. And then Larry Seams, who edited it, turned it into something turned it into what it is now, which is a well-organized document that tells a single story from beginning to end, and I could not agree more with Mark. I mean, it's this incredibly compelling read, and he's a very humane narrator. He's somebody who not only tells his own story, but tries to tell the story of the people around him as well, and is incredibly generous to the people around him and to the people like us who are, in some sense, responsible for his detention.
We must close this discussion now and move on to another panelist. And Rebecca Gordon will now address what are the effects of institutionalized state torture on the society and the effects on security and its character. So I want to begin by posing this question to Rebecca. How do we account for the phenomenon that as evidence of institutionalized torture accumulates, the willingness to hold people accountable seems to diminish?
It's really interesting, isn't it? Not only the willingness to hold people accountable diminishes, but the support for torture, as Mark started out saying, actually increases. The further away we get from those events of September 11th, the more willing people actually are to permit torture. And there was a Stanford study or poll that was done in 2012, and the woman who put together the questions said, as she was putting them together, she showed that a good at least 50% would sometimes or frequently think that torture would be necessary for our protection and therefore permissible. So she said on a lark, she threw in a question about whether it would be all right to use a nuclear weapon against terrorists, and 25% of the respondents said yes. Which, of course, suggests that these people, A, don't know what nuclear weapons do, and B, are not quite clear on what it is that gives torture its political power, which is that it is small groups of people able to do profoundly effective, what they used to call propaganda of the deed. But people had become so frightened and so accustomed to being frightened. So I think that torture has some very particular products in addition to producing occasionally information, although lots of times what you have is a pile of confabulation, information, things people think they remember that they don't. So one of the first cases of bad information that the New York Times talked about was before Abu Ghraib. It was in early 2004. There was a story about a guy whose name was Saddam Aboud. And it was unfortunate his first name was Saddam. He was picked up and taken to Abu Ghraib. He was a taxi driver. He was not actually guilty of anything, but he was tortured for 18 days before they started asking him questions. And this is straight from the New York Times. Then they started asking him questions, and they said, so, do you know Zawahiri, who was the leader, he was a Jordanian who was then the leader of what was called Al-Qaeda in Iraq. And he said, yes, not only do I know him, I'm his driver. And he actually believed what he was saying at the time, even though it wasn't true. So then they said, okay, well, if you know him, do you know Osama bin Laden? And he said, well, not only do I know Osama bin Laden, I am Osama bin Laden, but I'm in disguise. And the thing is, at that moment, he actually believed it. Yes. And the person who understood this really well was George Orwell. And if you remember your 1984, there's the point where Winston Smith, they keep turning the dial up on the torture machine, and he finally does see that 2 + 2 = 5. And so this is part of what torture doesn't produce. It will produce some information along with a whole lot of other stuff you have to sort out. But one of the things it does produce is enemies. And it not only produces enemies in the direct sense of people that are tortured by an entity they identify as the United States, are very likely to harbor some anger and hostility towards the United States. So and this is, before we left, this is actually becomes the rationale for not allowing people who've been held in Guantanamo to ever be released and to serve out any portion of their terms here in the United States. Because whether or not they were dangerous at the time, and even though they've been cleared for release, Congress has refused to allow people who are currently in Guantanamo to be brought and to serve out part of their term here in the United States. And so that is one of the reasons why closing down Guantanamo is so difficult. The other reason being that there are people, again, who've been cleared for release, but there's no place to send them that the U.S. feels safe about because, again, they fear that these people are now danger to us, even if they were not when they were picked up on the battlefield in Afghanistan in 2003. So you create enemies, but you also create enemies in the minds of the public. And this then gets reinforced by popular media, and I'm not an expert on popular media by any means, but you look at the movies and the TV shows and the fictional way that most people actually get their information about the world is not through reading news sources or even news sources on Facebook, but it's actually through fiction. And people have a hard time telling the difference sometimes between representations in fiction and the actual world. And so you have reinforced in people's mind the idea that there are these terrible, dangerous people. So we've produced these enemies. You've also produced forms of truth. You've produced the truth that Saddam Hussein was involved in September 11th and therefore permission for a war. And in addition, what torture does is it produces and reproduces torturers themselves. And this may sound a little odd, but the reality is that, in fact, people are not born knowing how to torture. The actual activities involved are physical skills, like any other set of skills, and they need to be maintained. You cannot just torture on a whim, which is part of why the whole ticking bomb idea doesn't work, because you need to have the infrastructure and the capacity. And so how do people get turned into torturers? In fact, in most cases, in most countries where there is a torture regime in place, there is also an institution whose job is to produce torturers and train them. And the way it works is that for the first period of time, you are, in fact, brutalized. You are beaten, you are humiliated. The upperclassmen in this institution are allowed to do whatever they want to you. And at a certain point, you graduate. And in the Philippines, that graduation under Marcos included something they called taking the Eucharist, which meant that you literally crawled through filth and were given feces to eat and urine to drink out of a chalice. And that was your initiation into this elite. And you now get to turn around and do what was done to you to other people. And so having survived this ordeal, there's this tremendous camaraderie that you develop with the people who've gone through it. So you might say, well, but we didn't do that. The United States doesn't do that. But in fact, we do. So,
Can I ask?
Yeah.
You describe in your book, and you're describing now, that torture is an institution with an infrastructure and replicates itself and so on. Now, but we also have intelligence gathering. We have security activities.
Right.
We're not going to get rid of all that.
No.
And we don't want, I don't think we want to. So we want to tame it. But so the question is there a way, given that there's this complex infrastructure, and I imagine in one way or another, surveillance, legal and illegal, is part of it, and so on.
Absolutely.
So how can we expect somehow to get rid of the torture segment
Without
and
getting rid of the rest of it.
without getting rid of legitimate intelligence activities?
So here's one wedge, I think, that exists, and it's within the culture of an agency like the CIA itself. There is actually a division in the CIA culture, and I have a number of friends who grew up in the CIA. Either their parents were in the CIA or they, and in one case, a friend who both grew up in it and then also worked for them for a long time. And they've described to me this division in the culture, which is between the people in operations and the people in intelligence. And it's a very deep divide, and in some ways, oddly enough, it's a class divide. And this, in fact, dates from the time of the Office of Strategic Services, the predecessor during World War II, OSS, to what became the CIA. And the folks who began the CIA were East Coast effete liberals from Princeton, Harvard, and so forth. They were the cream of the intelligentsia in many ways. And what has developed over the last few decades, starting really with Vietnam and the Phoenix program, but certainly through the wars in Central America, is this big divide between those who think of themselves as doing intelligence. And a lot of what intelligence involves is reading foreign newspapers. I mean, a lot of it doesn't even require a whole lot of surveillance. It's making sense out of information. And people who do operations. And so there's one possible wedge, and one way that we might consider. I mean, I don't think we're going to succeed in dismantling the CIA, but we might succeed in wedging off the operations piece and saying this is no longer legitimate. There is a precedent for that, which is the 1975 Church Commission. So the Senate Committee on Intelligence, when Frank Church of Idaho was the head of it in 1975, investigated what the CIA had been doing, not so much in, say, the Phoenix program in Vietnam, in which some 30,000 people were tortured and then dumped, a lot of them, into the South China Sea, but in the United States. And at the end of the investigations into what the CIA had actually been doing inside the US, cooperating with the FBI and COINTELPRO, and this all sounds very conspiracy, but it was Frank Church from Idaho, And there were 2 executive orders that were signed as a result of that by Gerald Ford, who was the president in that weird period after Nixon had resigned and before we had a new election. And one of them said that the CIA was no longer permitted to carry out drug experiments on the civilian population of the United States. Might be odd to think that that was actually an executive order, but it was. And the other was that they were no longer allowed to operate at all on U.S. territory. Another wedge that I think really exists is between the FBI and the CIA. So many of you probably know that there was tremendous disagreement between the Federal Bureau of Investigation and the CIA, specifically over interrogation methods. And so early on, the FBI was actually at Bagram, And they had begun doing some of the interrogations, but when the CIA arrived, there were big fights, and the same thing happened at Guantanamo about whether or not torture was going to be used. And their argument was, we actually have had a lot more success in establishing a rapport, getting someone to trust us. That doesn't mean you necessarily tell the truth to that person. Getting someone to trust us and getting them to eventually talk, and that, in fact, that is more effective and you get better quality information when you do that. So I'm not making an instrumentalist argument that that's what we should do because, or that torture is bad because it doesn't work as well. What I'm saying is, again, here's a wedge. Here's an entire infrastructure which has a different culture. And then a third possible wedge is between some portions of the military and the CIA. Because although it's true that in the civilian direction of the Pentagon with people like Donald Rumsfeld, there certainly was complete support for torture. But among some of the rank and file, people who are career military, there is actually a strong belief in the Geneva Conventions. And I think one of the reasons why the stuff that happened at Abu Ghraib happened is that those people who were responsible for the torture, the torture downstairs, the low-end torture, not the actual interrogation, were reservists. They didn't have the whole enculturation that people get in the military, which actually says, Article 3 is important, and we actually abide by that. So many folks that in the military that I've known, and especially like some of my vets who are in my classes, will say to me, this isn't what I was taught. I will say one other thing, which is about how our people get trained. So there's a school called Survival, Evasion, Resistance, and Escape, SERE. And not everybody who goes through that training becomes a torturer. But I have talked to people who did go through that training, and what they say to me is exactly what I said. There is a camaraderie and a sense of superiority that you have after you have survived that. And you feel a connection with the people who went through it. And when you're done, you know how to do the things that were done to you, and you have permission to do them yourselves. So it may be a smaller version of what they had in Brazil or what they had in Chile or in Greece or in the Philippines, but we have our own little version. And there are those who argue that even basic training, to the extent that the purpose is to take the person apart and recreate that person as a soldier, and to the extent that it's done by hard physical and emotional experience, is a low-class sort of softened version of the larger thing. So
Let's let our panelists respond.
please, sorry, go on.
What did you say, Bill?
I was getting time for our panelists to respond. We do have more time.
On this subject?
Yes, yeah.
No, I'm fine. I wanted to ask another question of Jameel, but
Go ahead. I yield.
You yield?
I yield.
I'm just wondering if you could tell us how, as a lawyer, you deal with the government's different forms of national security arguments. I mean, is there a way in which you try to accept them and go around them, or do you try to discount them or disagree with them? How do you deal with it? I mean, because that's their big pitch.
I think for the most part we try to go around them. We try to accept them and go around them, and that's because the courts are very deferential to executive branch officials on issues relating to national security. So if the CIA says, if you release the font of this document, the sky will fall, it's unlikely that a court is going to say, that doesn't sound reasonable to me, even if it's as crazy as that particular claim. We have another case involving the drone program, and we argued that the OLC memos relating to the drone program should be released, and one of the arguments that we made was that the government has already disclosed a lot of the legal analysis that's in these memos. The government has trotted out many senior officials to defend the drone program, and the way they've defended it is to say that the OLC has concluded that this is lawful, and here's the OLC's analysis. So they'd already talked about it publicly. Harold Coe had talked about it. Eric Holder had talked about it.
Jay
Johnson had talked about it. John Brennan had talked about it. The president had talked about it. And we said, how can they talk about this publicly and then claim that these documents have to be withheld in their entirety? And the district court in that case actually upheld the withholding of the memos. The district court said these memos can be kept secret for national security reasons. And in the introduction to the district court's opinion, the district court judge, Judge Colleen McMahon in the Southern District of New York, she said, I understand the Alice in Wonderland quality to this opinion. And she says, in my view, all of this stuff should be made public. I don't understand how the government can go out there and claim that its policies are illegal and then withhold the very things that would allow the public to verify that the policies are in fact legal. Nonetheless, she said, the law as it's given to me requires me to defer to the CIA's claim that the release of this information would jeopardize national security. Now, the Second Circuit actually overturned that, and that's why we have one of the drone memos right now. But as a general matter, the courts have been extremely deferential on claims of national security, and so the only shot we have really is to accept the government's factual claims and instead make legal arguments on which deference isn't usually accorded or not accorded to the same extent. And so rather than argue that the release of information won't cause harm, we argue that what the information of the government is trying to keep secret isn't source and methods information, which is a legal question rather than a factual question. And since it's a legal question, we argue that the courts don't have to defer, or at least don't have to defer to the same extent. And the same is true in the state secrets cases. We accept, for the purpose of argument, that the facts that the government is pointing to are in fact secrets that can't be disclosed, but we argue that we have enough facts, even without those facts, that the court should be able to adjudicate the case or resolve the dispute without reliance on the facts that the government says is secret. So it's all a matter of sort of, accepting what the government says is true and finding ways to, to circumvent those things which we are forced to accept as premises. Now, even when we do that, obviously, we are not always or even usually successful at getting courts to order the release of documents or getting courts to adjudicate claims on the merits rather than throw them out at the doorstep. But it's really the only, the only way that has any hope of succeeding.
It strikes me as you're talking that this goes back to your opening remarks, which I found fascinating, about this world that we've created, which I've written about before and called it public secrecy, where, the drone program, you can read about it, there's a drone strike, you read about it in the newspaper. Sometimes, as you just pointed out, high officials give speeches about it, but in fact, it's secret. That is, actually, we don't claim responsibility for these attacks. We don't accept responsibility for them. When Abu Zubaydah was captured in March 2002, President Bush happened to be talking at a fundraiser in Greenwich, Connecticut, of all places, and said, well, the other day we captured this guy, Abu Zubaydah. He's no longer making mischief. He's where he should be. He's getting the treatment he should get, or something like that. But the official position of the government was, we don't have him. We don't know where he is. We don't have responsibility for him. There's no, it goes back to the very basis, of course, of habeas corpus. We can't produce the body. We don't have him. We don't accept this. And it's an immensely, I think Jameel, said it very eloquently in his remarks, that we've created this world of public secrecy in which we all accept that certain things, some of them the most important things in the world, like how our country is making war as we speak, how we're responsible for killing what's now probably 4,000 people through drones, for example, and we have allowed this to be classified as a secret. That is my point, that we have, actually just following on to what Jameel's original remarks, that we've created this large world that we dub secret, that the government dubs secret, but it encompasses the most important things that the government and we as a country do, and it's in fact not secret. It's not secret. some of the details, and some of these details are very important, some of the details, like the arguments for its legality, for the legality of drone strikes and so on, are secret. But the actual fact of the matter, how we're making war, isn't secret at all. It just shields the government, in effect, from responsibility, which strikes me as just profoundly undemocratic.
Bill, can I just have 30 seconds on that?
Yeah, go ahead.
One point?
Go.
So just to give an even more extreme example, the day after the CIA killed Anwar al-Awlaki, who's a U.S. citizen who was targeted, killed by CIA drones in Yemen in September of 2011. The day after that strike, President Obama held a news conference and said that we took him off the battlefield, explained what a danger the government thought Anwar al-Awlaki had presented to the country, justified and in some ways celebrated the killing of this American citizen overseas. A week later, the CIA filed another brief in our Freedom of Information Act litigation saying that the government had not acknowledged any role in the death of this U.S. citizen. And they did the same thing after we filed suit on behalf of Anwar al-Awlaki's family, a constitutional action against some of the officials who authorized the killing. And the government said, we have not acknowledged that we had any role in the killing of Anwar al-Awlaki. Now that's changed now, but that was.
Can I ask you something? This is a profoundly unlawyer-like question, but how is it that the president, the actual executive officer of the government, can make this announcement and discuss this case, and then the government get away as an official position denying that the government has acknowledged it? I've always been somewhat perplexed by that.
Well, there's a kind of casuistry, is that the word, that goes on where they parse every statement. So what president, I don't remember the precise words that he used, but he didn't actually say, we took him off the battlefield. He said something like he was taken off the battlefield, but then he referred to the great job that the CIA had done. And what they say is that, well, we don't explain, what the CIA did. In theory, the CIA could have just provided information to our allies, and the allies could have taken him off the battlefield. We never acknowledged that we took him off the battlefield. There was another instance in which Panetta had been on 60 Minutes, and the interviewer, I can't remember who it was, said to Panetta, "Now you were responsible for killing Anwar al-Awlaki," and Panetta nods, but he doesn't say anything. And we later introduced the video. We pointed the court to the video of this, and the government said in its response brief, the transcript conspicuously lacks any acknowledgement on Panetta's part that the CIA played a role in the killing. But if you look at the video, Panetta nods, when he's asked this question. So it's that kind of thing. Until very recently, the courts were accepting all of that. 2 appeals courts now have started to push back, one in D.C. and one in New York, and I suppose that's a hopeful sign.
Okay, we must allow time for my co-conspirator, Bob, to address the topic he wishes to speak to, and that's what can we ask of lawyers and legal institutions to prevent torture and create conditions of accountability? And my question for you, Bob, is would you like to see the development of curricula at U.S. law schools that would closely examine detention, interrogation, and torture in light of U.S. constitutional law?
Well, I want to respond to that, Bill, and then if you feel we've run out of time, we can go to the Q&A.
No, we go ahead.
Anyway, I want
speak.
to respond to what you just said.
Yeah.
I think that there are different ways that we could work some awareness of torture into the curriculum, and it can be generalized. I think, for instance, courses in national security, which would deal with torture, surveillance, all kinds of issues, would be a very good kind of course to install, for instance. Of course, I'll go through a couple of other suggestions. Let me say first that the way that law school curriculums work is that pretty much anything new has to just be thought up by some individual professor. And he or she wants to teach a new course, and we have a number of rather basic courses that people ought to take and have to be given. We have lots and lots of electives. And so people think up courses that they want to teach. And, but we do it as a kind of laissez-faire thing. No one goes around saying, we got to have courses and this and that thought up. If somebody comes up with some money, some foundation says, we'll give you money, you can think up a course, people respond to that kind of thing. So I think on the laissez-faire level, it would be very good to have courses on a course on national security. Another possibility that we could be more organized about is to have our curriculum committee get segments on torture, let's say, or on surveillance that could be inserted into an ethics course, for instance, a legal ethics course. We could, and I think that, I don't think we do enough myself with legal ethics. Our course is required. I think it'd be very good if we had a kind of a whole program in legal ethics, and I think that would get into the role of the government lawyer. We could have a course in the government lawyer. So I'd like to see a lot more, yeah, and I think there are the real options for it, and we do have some people in the law school are teaching a couple of hours on torture in an ethics course, or we have a social justice curriculum, and I think some of the courses there include a bit on these issues. But I don't think we have a really, we don't have a systematic or just a disciplined approach to that, I think, at Bolt, and I'm not sure about other law schools. I just don't know what's going on. But one of the things that we should be doing, is finding out, what are you doing at these other schools?
I'd like to put in a bid to have taught the Office of Professional Responsibility report from the Department of Justice, which is just a remarkable document, I think, that really describes how it was that the elite lawyers in the country, including the young elite lawyers at the Office of Legal Counsel, came to approve torture. And it's this document that I look at it and I think, gee, I wish every lawyer here could read it before they graduated. That, along with the memos themselves.
When I went to law school, between our first year and our second year, over the summer, we had to read a book. It was on advanced accounting. But we could try what you just said. I mean, we ought to have...
It's much more interesting than advanced accounting.
That's what I was suggesting. We ought to... It's perfectly sensible to have a few classics that every law student ought to know. And some of these classics are books that were published a long time ago. But what you're saying is this OPR report would be a beauty, and it would be. You're quite right. It's a very good idea.
It's got a kind of immediacy about it.
It has
that I think
immediacy,
is
and
exciting.
it's about legal ethics, and you don't have to be a government lawyer to learn from it. Yeah, that's a great idea.
Are Professor Emeriti allowed to initiate courses at this law school?
They do. They are allowed if they have the energy for it.
Do they have to then teach them?
Yeah, well, I mean, that if you want to start a course, you're probably going to teach it.
Yeah.
Yeah. Well, one of the things that I've learned from you, Bob, is that the essential role of a lawyer is to try to calm the client down. And I think that itself has got ethical implications. Because as a mental health person, when you're working under anxiety, you tend to become a delusional, I think. And so
Well,
your judgment is impaired.
It's a perfect example of that.
Say it again?
The panic
Oh,
point.
okay.
People,
Yeah.
I mean, I'll give you another example of panic, which is
Please
nothing to
do.
do with torture, but it tortures me to talk about it. During Bush v. Gore, during the Florida recount in Florida, when the case came to the Supreme Court, they committed a range of atrocities that were as bad, or maybe as bad as Dred Scott. It's the second worst opinion, I think, in history. And I thought about how could they do this? And I think they panicked because they saw this
Yeah.
Southern Democrat-dominated Florida Supreme Court deciding the presidency. Because the Florida Supreme Court had said, we're going to have a recount and count these hanging chads, whatever.
Yeah.
And I think the Supreme Court, at least some of the justices, panicked. How can they decide the presidency and not we? And I, you see this panic all the time.
Amazing.
The judge that
covered that
the
recount.
justice that I clerked for was an old pal and a very, very wise man. And he said, and he'd been in politics, said, people vote out of fear more than anything else, which was what Mark started with, I think. And so it's the whole, what a lawyer has to do is not get sucked up in the excitement and the panic, but just the opposite, and step back. And your job is to be a disinterested counselor. Now, there are times when you are an advocate, but when the White House is asking you, what can we do by way of interrogation, that you're not an advocate there. The problem with the torture memos is that it is advocacy, bad advocacy. But you're a disinterested counselor with very high stakes, and that's how you have to behave. So you're quite right.
And I think it's really important to see the lawyer who is approaching or taking that disinterested position must take courage. He must use courage.
Yes.
And we haven't used that word here on this panel, but I think it's very important to
And
Well, that's what Brandeis said in one of his famous cases, that the people that started this country by revolution were not cowards.
Yeah.
They had courage, and then of course he uses that, he expands on that to say you got to have courage to allow free speech, to allow the speech that you hate. And so you're right. Now Bill is, I'll just put in a plug for him. He's working on a project now of civic heroism.
civic courage.
Civic
Yeah,
courage.
which may
And-
be heroic.
And
but
the point of
civic
it is, he wants to find ways that people can get support for taking courageous acts in the public interest. Yeah, I agree with you.
So can I bring in my guy Aristotle here?
Yes, we have time for Aristotle, and then we
So
should give the people.
Aristotle says that the moral virtues are habits, that they're not things that you just come upon suddenly, but you get brave by doing brave things. You become just by doing just actions, and it's almost like fake it till you make it. And I think that as a people, since September 11th at the very least, we have been encouraged to be the opposite of brave, to be cowards, to accept anything as acceptable to prevent danger to ourselves, to prevent, and we have a word for that. If you'll allow anything to happen to prevent something bad happening to you, we call that cowardice. And I think that I'm really interested in your project, and I think it's not just rewarding people for being brave, but I think giving people opportunities to practice bravery, because most of the time when we make ethical decisions, we do them, if not in moments of panic, at least in times when we don't have a lot of time to reflect. And if we're not going to have a lot of time to reflect on what we're going to do, we better have good instincts, and we better have good habits. And so we need to develop courage.